Hey guys, today we're going to talk about termination clauses. What is a termination clause? A termination clause is found in a legal agreement, a contract, that allows for the contract to be terminated or cancelled under circumstances specified in the clause. Most contracts give parties mutual ability to terminate the contract. Mutual means reciprocity, reciprocal, both ways. So most contracts give both parties the ability to terminate the contract by giving notice. For example, 2 weeks notice, 2 months notice. However, some contracts are one-sided. Only one party can terminate. For example, like franchise agreements, distribution agreements. Why is it one-sided? Because, for example, in a franchise contract, the franchisor, the person giving the franchise, does not want the franchisee to simply terminate the contract whenever he wants, close the franchise, the restaurant or whatever, and just leave the franchisor in the lurch. That's why in such contracts, especially franchise contracts, the franchisee, the person getting the franchise, has no ability to terminate. But even if the contract does not allow the franchisee to terminate, there is an implied right of termination in the event of breach of the franchisor. Some termination clauses provide one party to terminate for specific events, for example, bankruptcy or insolvency. Bankruptcy is for individuals, insolvency is for companies. Mergers and amalgamation, because the entity merges with another, so the other party may not want to deal with a new entity. Changes in shareholders or directors, same reason. The party to the contract does not want to deal with a company where there's totally new owners and management. Another frequently seen reason for termination would be criminal offences, whether by the directors or the companies. And another common reason that allows for termination would be a material breach of the terms of the agreement. And the clause will usually state a material breach, and the breach is not remedied within a specified time, for example, 14 days. Sometimes the agreement allows you to terminate immediately without notice for major breaches. In such cases, because there's been a major breach, the innocent party will terminate the agreement and then sue for damages. This is usually for breach of a condition. You can watch the you can watch the other video I did on breach of contract. What are the consequences of termination of contracts? Well, the usual consequences are the return of all material that has been provided by the parties. There will usually be a clause specifying that the parties have to destroy documents in their possession. There will also usually be a clause that the parties have to settle all remaining payments or refund monies due under the contract for work or services that have already been provided. So thanks for watching this video on termination clauses.